Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
On today's episode, we're going to talk about how the new auto law is impacting quadriplegic auto accident survivors, an interesting sexual assault case that resulted in an acquittal, and picking a school for your child.
In the name of personal injury law.
We have been covering many aspects of the 2019 amendments to the Michigan Auto No-Fault Insurance Law. Today, we'll take another look at the effects these laws are having on catastrophically injured people. We have personal injury attorney Steve Sinus with the Sinus Dramus Law Firm here today with us, and he has brought with him a special guest. Steve?
Thank you so much for having me, Lisa. I'm very honored to have a special guest here. It's Brian Woodward. He's a friend, he's a colleague, he's also a client of mine. And he has a very compelling story to share about how he sustained catastrophic injuries in the form of a spinal cord injury in a motor vehicle accident that happened on November 5th, 1983, and how the no-fault insurance system throughout the past several decades has served him well, and how things have gone exceedingly different for him over the last year due to the changes in the law that was passed in 2019. So I'm very honored to have Brian on. Brian, thanks for being here.
Thank you for having me on. I really appreciate the opportunity.
Well, welcome, Brian. So first, can you tell us a little bit about how you were injured and also how the no-fault law has helped you over the years?
Yeah, when I was first injured, it was in a single vehicle accident. We rolled over and I was thrown out and I broke my neck at the C4-5 level. And it left me paralyzed pretty much from the chest down. I have no functional use of my arms or my legs. And from there, there's other medical complications as well. But over the years, I've been able to, because of the support from No-Fault, I've been able to kind of regain a life. I started out after my accident, returning home to my parents' house. And from there, it was kind of boring just sitting around. So I started coaching Little League, and I coached Little League for 6 years. And then I needed to get a job. And I figured the only way I could get a job is I needed a better education than what I had. And so I went back to school. And I graduated from Northwood University in Midland with a Bachelor of Business Administration degree. And I graduated magna cum laude. And so after that, after graduation, I went back and tried to get into the workforce. And I was able to secure a job with a contracting company who contracted me to one of the big three automakers. And I was a computer support person there for 30 years. And in that 30 years, I was able to pretty much create a normal life. The previous no-fault law, the whole gist of that was to return people back to as normal as possible as they were before their accident. So I was attempting to do that. And as I said, I was working with one of the big three automakers. And I eventually bought a house in Detroit. And throughout those years, I was like I ended up buying my own home. I pay my own bills. I pay my taxes. I mentor young children. I mentor other disabled. I participate in my community. A little trouble breathing right now, but 1 second. But yeah, I participate in my community, and I've actually, participated in my church as well. I sang in the choir, and I taught vacation Bible school, and did most of the things that normal people did. And I thought I fulfilled the gist of the no fault law as best I could.
Thank you for sharing that. I was going to let you have a chance to catch your breath while I have a question for Steve. Did Brian's legal rights change with the 2019 amendments?
Yeah, and I'll get to that question. I just want to emphasize that all those amazing things that Brian did after his spinal cord injury, he did because of his own perseverance, his own will, but he also had the care he needed so that he could go do those things. So he was maximizing his ability to do things through the care that he had to support him. And so that was so fundamental to his life. And to get to your question, Lisa, the issue that he's fighting for is whether anything changed under his contract of insurance, his rights as established under the old law by what the legislature did in 2019 when they amended the law. And there are lots of legal fights playing out in the courts about whether people like Brian, whether their rights were changed by the 2019 reforms. The insurance companies like Brian's is arguing that they can apply the new rules to him, so that he now has to talk to his care providers about receiving 45% less than they were receiving just 2 years ago. And he also has to deal with the restrictions on family provided attendant care and all the other limitations that the legislature put into effect in 2019 when he was injured in 1983, sold a policy that didn't have any of those rules in it. And so he's part of this fight that's going on about whether these new rules should apply to people who were insured under these previous contracts. And in the meantime, Lisa, the thing is that he's got to find care as if the new rules do apply, because that's what his insurance company's saying. And so he'll get to the trouble that he's had over the last year because of that issue.
So Brian, how has the insurance company's application of these new rules changed your life?
Yeah, as Steve has said, the burden of having medical expenses was lifted under the old no fault law, but now they're, like he said, it's my caregivers have pretty much all gone away because they couldn't afford to keep a job that paid so little by getting their pay slashed by 45% also. And so it threw me into a dilemma where I had to end up going to like a rehab facility to have a roof over my head and some margin of safety.
So is that where you are now, Brian, instead of at your own house?
Yes, I haven't been in my house for almost a year now, ever since the law took place. And I've had to live here, and my medical condition has definitely declined because of not having the one-on-one care. And I've had many hospital visits and many close to death experiences for being in not the correct one-on-one care. There's such a gap between the one-on-one care, and people here have like maybe two assistants for 13 people, and they can't be right with you. So I experience anxiety for possibly dying at any moment because I didn't have anybody with me.
And so I just want to say in closing, I just thank Brian so much for coming on to tell his story. It's obviously now a sad one when it was really one of triumph following such tragedy. And hopefully he gets his rights restored by the courts. We'll have to wait and see, though.
Thank you, Brian.
Yeah, and just real quick, I have lost my job and all my medical and the ability to pay my own bills. And I used to go on vacations and stuff like that. Can't afford to do that and can't find anybody even to take me to church anymore. So that's really changed my life a lot.
Wow.
That's where we're at.
We'll keep fighting, Brian.
I will keep fighting.
Good. I want you to.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. In the Name of Criminal Defense.
Welcome back to Criminal Defense Attorneys Takura Nyampakusta and Mary Chartier. Now, I hear that congratulations are in order for a recent victory that both of you just obtained in a very lengthy jury trial on an accusation of a serious charge of sexual assault.
Yes, thank you, Lisa. It was multiple weeks. There were 6 criminal sexual conduct in the first degree charges, which is the most serious level of criminal sexual conduct in the state of Michigan. Those are life offenses. Our client could have drawn her last breath in prison. It was a lot of work, many years it took for the trial, in part because of COVID, but it was a 12-word verdict, as Takura says, 6 not guilties across the board.
Wow. So 20 years, isn't there a time limit for prosecuting cases?
Well, in Michigan, we have 4 degrees of criminal sexual conduct, and we abbreviate that to CSC. While the others do have lengthy time limits, there's no statute of limitations, which is the amount of time that's allowed to pass from when an alleged criminal act supposedly happened and when it can be brought to prosecution. For CSC in the first degree, there is no time limit. So there is no such thing as an easy rape case, no matter the degree. But the passage of time in this case did present some unique challenges in this case, I'll say.
Well, I really want to know, why was there such a long delay, and what would motivate a prosecutor to bring charges 20 years later?
Well, in this case, the complainant had indicated that it was a repressed memory, so that the memories were there, then they had left, then they had come back. And then for prosecutors, I can't speak to why they would bring charges, but they think that they can successfully prosecute a case. And obviously they were wrong on this one.
So what are some of the unique challenges that you find in a case where the claim is from so many years ago?
Oh, there are so many, right? The memories fade. If you ask someone, what did you do even a month ago, a year ago, 5 years ago? Now we're asking people about 20 years ago. Locations look different. Records are gone. This is not the first 20-year-old accusation we've had to defend against. Takura's, but we've worked on so many of these cases together, but business is shut down, and there are people who don't want to get involved after all that time. They don't, they might feel bad for the defendant. They might have information they want to share, but they're retired or they work at a different job. We had one woman in a case where Takura kept calling. We were certain it was her phone number. And then she kept saying, no, that person is not here. He went to the address. She said, no, I'm not that person. Ultimately, another woman who knew her said, you've got to talk to him. And it turns out she testified she did have factual information. And, and she was a key part of the case.
Wow. So what do you do when a claim is from such a long time ago?
Well, again, everyone who comes through our doors gets the same vigorous defense available under the law, whether the claim is from 20 weeks ago or 20 years ago. But again, as Mary mentioned, investigation is something that's critical, and we start at the very earliest stage. There's no such thing. And again, people come to us before charges have even issued. And there are things that we do in that instance, again, to shore up the defense should the case end up going to trial.
Sorry, but hopefully in that case, convince a prosecutor to never charge the individual. So we've had so many victories, and I kind of put that in air quotes, when we've never had to go to court because we've been able to convince prosecutors either in our client's innocence or that they would never be able to successfully prosecute the case.
So outside of investigation, what do you do in advance of trial to shore up the defense of your client?
Well, there's a lot. There's so many witness interviews, trying to track down documents. We always try to go to the scene if we can. It makes it challenging when it's a 20-year-old accusation because in one case, the business had shut down, but we always try and be able to see, well, could it have happened the way that the complainant is saying it's happened? A lot of trial success is preparation. It is just going over the documents that you've been given by the prosecutor, but more importantly than that, seeking out other documents. I mean, we had one case where the defendant said, I was at work, but not the prosecutor, not the police, and not his original lawyer ever thought to go to his work to confirm that he was there. And you don't have to be Sherlock Holmes. If you went and checked his work, he was at work. But it took so long to actually get those records and prove that. And then there's a lot of pretrial motion practice in a lot of cases about trying to obtain records, about hearsay statements, rumors, things like that you shouldn't come in at trial. There's just a lot of work. And I think that's one of the common misconceptions is that, well, I can just go in and say it didn't happen, or we can just go in and argue that it didn't happen. But there's so much that goes into it. And the case that we just wrapped up, I mean, there were hundreds and hundreds and hundreds of potential exhibits, probably even thousands. But ultimately, we had to winnow that down to probably about 150, which is still a lot especially in a criminal sexual conduct case. And then we had to make sure that all of that was organized and see how that fit in with the defense.
So can a person be convicted of rape if there is not any physical evidence?
Unfortunately, the answer is yes. And often the primary or only evidence is the word of the complainant. And no matter what the evidence shows or how much of it points away from the accused, anybody can end up sitting in a chair between me and Mary. Also, there are presently 3,118 people on the National Registry of Exonerations. That means a person who was convicted of a crime, but was later found not to have committed that crime. And some of these folks spend as many as 30 or 40 years in prison. But in this instance, those exonerations equate to 27,080 years lost. Many of those people were convicted of rape and other crimes based on the testimony of a single witness, Lisa. So it's impossible to overstate the importance of starting a thorough investigation right away. That's true, like I said, whether it's a 20-week-old or 20-year-old claim. Our investigations often lead up to and continue into a trial. You remember the Grand Rapids one, Mary, where
right.
I left in the middle of testimony as somebody was testifying to go and track down some documentation.
Right. This is testimony that no one had ever said anything about this before. Witness would not be interviewed by us. It was a government witness. Government witness made a claim. And then we were like, that doesn't sound right. And so Takura went off and checked it out. And sure enough, it was not right.
So this is why you have two of you at trial, right?
This is why two of us and a paralegal all the time. And Takura mentioned the National Registry of Exonerations. We have placed 4 people on the National Registry of Exonerations. A man who spent 9 years in prison for a rape he did not commit. Another man who spent 9 years in prison for a murder he didn't commit. A woman, 18 years for a murder she did not commit. And a man, 26 years for a murder he did not commit. In the rape case, there was nothing more than an allegation made by the complainant, and we were able to prove that that's false. So it is real. People really get convicted based off false testimony. And then once someone is convicted, it is so much harder to reverse that. I mean, Lisa, you are an expert in appeals, right? I mean, you have been so successful in the family law cases that you have handled. For criminal defendants, once there is that conviction, it is very difficult to get an appellate court or a federal court to take that seriously. It's much more challenging. And so what Takura said is 100% correct. You've got to try and do everything you possibly can to defend that individual before they spend 1 minute in prison. And, we cover these exonerations and so much more on our podcast. called constitutional defenders. I think the stories that are told by people who've been wrongfully convicted and then have been released are, to me, some of the most fascinating stories, and they're very compelling. And one thing is, Michigan has done absolutely nothing to stop wrongful convictions. There has not been one task force or one committee put together to stop this from happening.
And I also want to point out, we've had at least 3 episodes where you brought in guests and talked about specific exonerations in Michigan. So I think it's worth watching those episodes again if this is a topic that's of interest to you. Thank you, Mary and Takura.
Thank you, Lisa.
Thank you for having us.
In the Name of Criminal Defense is brought to you by Chartier Niamfakusa PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law. I'm here with Kent Wood, the lead attorney and owner of Wood & Associates, a family law firm. Welcome back, Kent.
Well, thank you, Lisa.
Well, today we're going to be talking about parents having to pick a school for their children when the parents don't live in the same households. So start it off, Kent. Tell us about how do we pick schools?
Well, first thing is it comes down to what's the legal custody arrangement. Legal custody is the major decisions regarding education, religion, and major medical stuff. If you have sole legal custody, where it's just one parent's responsible, they can decide and that's it. There's nothing else. But most of the time, the problem is that they have joint legal custody where the parents have to co-parent, make the decision together, and they have to decide which school the child's going to go to, whether that's starting school because the child hasn't started school, or whether that's potentially changing schools for the sake of the child.
And I know that parents I've seen disputes where they can't even agree on preschool. So we're sometimes starting the conversation very early.
Yes.
In the lives of their parenthood.
Yeah. So if you're going to once you decide to have this conversation, the court's going to look and see if there's what's called the established custodial environment and what impact going to school will do to the current parenting time schedule. Sometimes there may be a shared parenting time schedule that has to become a every other weekend schedule or something different because of the distance between where the parties live and just the actual flexibility and logistics of getting the child to school.
And that happens a lot when the child is going from being in daycare to kindergarten. All of a sudden they're in school full time, and the fact that the parents live a little bit of distance from each other really makes a big difference in the lives of how that family is going to have to interact, right?
Oh, well, definitely, because you can miss preschool and it'd be okay. You can get in some trouble with the law if you miss a lot of regular school.
Right.
But they look at all the factors that you have to look at when you're even establishing custody. They call them the 12 best interest factors. But the ones that matter are like the education history of the child, the change of the stability and getting the child around, the impact on the family unit of each home, the home school and community record if the child's already in school, and then just any other special needs of the actual child. If your child has a developmental issue, or speech, vision, hearing issue, and they need special services, you're going to want a school that can offer those. Now, every school is supposed to provide them, but some, reality is some are better than others, and that will become a major factor in determining what school the court will choose. Again, the court's only going to choose if you guys can't work it out together.
Right, so the parents can agree on a school, and if they can't agree, one of them can file a motion asking for the judge to pick a specific school. So what do the judges want to hear about when a parent's doing a motion to pick a school or change a school?
They want to hear about all the facts of how good the school is, compare the two schools, travel time, getting to and from school, what times kids are getting up in the morning. What's your plan to get the child to school with respect to your work schedule? They want to know all of those things because they want to see what the impact on the child is going to be. They're not too concerned about what the impact might be on the parenting time when they're picking school. They're really focusing in on how is it going to affect the child. And it really comes down to logistics. We've had several cases where, one parent worked at 6 a.m. every day. They were home by 3, but they were going to have a difficulty just getting the child to school. So even though the school was good, decent, comparable schools, it came down to just a very logistics kind of a thing, fortunately or unfortunately. The problem can be also is when parents live substantially far apart, right? When they live like 60 miles apart and your child's going to be in a school district and develop a relationship with friends and you don't have a connection to that community. And that's going to be difficult to understand, but at the heart, it's always, again, focusing on the child, not on the parents. So you got to find ways to work that out.
So if the school that the judge ultimately decides, because the parents can't agree, actually is going to have to impact the parenting time of the other parent, What is there more that the judge has to do if it changes the child's established custodial environment with from both parents to just one parent?
Yes, the judge will have to try to find a way to kind of recoup some of that lost time or change, whether they make it up in the summer, and that's a big way that they make it up usually is making up more time in extended summers, or sometimes during the school year with the breaks or things there. It just really depends on everybody's schedule. And I've had parents have the child in the middle of 2 days of the week of school, so if they can get them there, because the dad had worked and his weekend was basically Thursday and Friday, so the child was with him on Thursday and Friday, and he was able to get the child there. But it was still a bear, even though it works for him and he has that connection. He was getting up an hour earlier on his day off and having to travel 30 minutes both ways just to get the child to.
I mean, something I noticed that after, we had the COVID shutdown and a lot of kids were remotely going to school for a period of time, parents who may not have been really that involved with school suddenly became like every week or every other week were basically in charge of the schooling and making sure the kids were involved with school remotely. Did that create a lot of conflicts going forward now that we're back in school, that parents who maybe were not as involved with the school then now that they've had this experience of doing it for a year and a half, they want to be more involved with the school decisions?
Well, absolutely. I had a specific case where that happened. One parent lives in Michigan here, the other parent lived in Kentucky. And because of COVID and school being online for a year, they were able to do an extended stay, parenting time with the parent in Kentucky, just because of the schedule allowed it. And they were all, you can Zoom from anywhere, right? And so it did allow that to be more involved and have the daily activity. And that overlaps into the parenting time schedule and custody issues, because now you have this established custodial environment, this world where the child has now been going to school like 10 days out of the month from dad's house and 20 days out of the month from mom's house. And dad liked that. And he wanted that to continue. But COVID kind of changed and they went back to in-person. And then we've seen a lot of arguments and fights come through. And again, it keeps coming down to logistics. I mean, there's just no way he can exercise that kind of parenting time from so far.
What about when one parent wants to homeschool the child?
Well, homeschool, again, is that what's best for the child, and determining that what's best for what's the quality and knowledge and education of the parent that wants to do that, because can the parent provide a similar or equal level of care or education and instruction that a trained teacher can certify, and if there's any special needs, can they provide and address those as well? So it's still treated just like another school district, but more specifically to the abilities of the parent.
Do you have any last tips you want to give to parents who are having difficulty agreeing on their schools?
Well, know your child and go and meet the school and talk to the school people, the instructors, the parapros, the principals before they get there.
Great. Thank you, Kent.
Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.
See you next week on In the Name of the Law.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.